Hi guys, welcome back to Battle with Ola. This is Mujala Olu and I'm so thrilled to be here once again. Today I want to do a quick video, a very short one on the line of succession for an intestate or for someone that has died intestate, that is they've died without making a will. I've done videos on wills and codices and obtaining letters of administration. So I want to talk about who are those that can administer their estates, who are those that can oversee what they have left behind, that can take it over, that can use it, that can manage it, that can dispose of it, and who are those people under the law. And I'm talking about this because I get a lot of questions about it. Recently I was consulting for someone whose father has just died on Saturday. I was consulting with her, and then she also asked this question, so I just want to lay it to rest by doing this short video. So I'm just going to be listing the grades or the gradation of succession under the law. That would mean that if the person that died was married under the law, that is, if it was a statutory marriage that was conducted, and if the English law was their personal law while they were alive, what would guide their the succession of their estates, what would guide who can obtain letters of administration, for instance, over their property. That's what we want to talk about in this video. Please note that this one is for someone that has died and has not made the will. For people that made wills before they died, there's a different line of succession for them. People that can take over their property, to administer, to manage it, to sell it, to use it. But this one is for people who die without making a will. That's why we have called them intestates. So they have died without making a will. They have died in intestacy. So who are those that can obtain letters of administration to manage their property, dispose of it, use it, and what have you. And the first person is a surviving spouse. So if the person's personal law was English law, that is, if for instance they were married under the act, the surviving spouse will be the person that would be able to administer their estate. So if someone has died now, a father has died or a mother has died, the surviving wife or husband of that person would be the next in line to obtain letters of administration. Now, for obtaining letters of administration, the law usually requires 2 or more administrators. So one person might not be able to do it alone. So the next after the surviving spouse are the children of the marriage. Children that are at least 21 years old, at the time of applying for the letters of administration. So it will be the wife or the husband and a child. If you want 2 administrators, if you want 3, the wife or the husband, the surviving wife or husband, and 2 children that are of age, that are 21 years and above. So the next in line are grandchildren of parents that died. What we mean by that is that if, for instance, someone had children and the children also had children, and now the first child, that is the first generation, has died, so the child of that child can also administer the estate of his grandfather or grandmother. They would come next after immediate children. Grandchildren of parents that have died can come immediately after children. So do you understand? Children, then grandchildren of parents that have already died, and then we have father and mother of the deceased. That's the next in line. Father and mother of the deceased. After them, we have brothers and sisters of the full blood. That is, brothers and sisters of the deceased that were given birth to by same father and same mother, not half brothers or half sisters. And you can now see that before it comes to brothers and sisters, we have about 3 people ahead of them. So that's the law, because in most cases, we find that it's the truth. This is not an indictment. We find that it's the brothers and sisters of the deceased that are usually, trying to foment trouble when the deceased person has died. So they are usually the ones that want to, take over property, throw out the husband or throw out the wife from the equation, and sometimes even throw out the children from the equation because they want to take over the property of their deceased brother or sister. So you can see that before it comes to you, under the law, we have the surviving spouse, we have the children of the married that are of age, and then we have grandchildren of parents that have died. They can administer the property of their grandfather or grandmother that has died, before, and then we even have father and mother of the deceased before we even come to brothers and sisters of the full blood. After them, we have brothers and sisters of half blood, that is, half brothers, half sisters, people that are not necessarily same father and same mother with the deceased, so they can come and apply for letters of administration and administer the estate of the deceased person. Then we have grandfathers and grandmothers. After half brothers and half sisters, we have grandfathers and grandmothers. And after them, we now have uncles and aunties. In some other instances too, uncles and aunties try to foment trouble. So you can see that they are very far in the line of succession. We have uncles and aunties after grandfathers and grandmothers. Then we have creditors of the deceased. So if the deceased was owing any debt, his creditors can also apply for letters of administration to recover what he owes them. And lastly, we have the administrator general, that's the state. So if none of these people are available or cannot be found to come and apply for letters of administration to manage the estate of the deceased, and the deceased did not make any plan or leave any guideline or instructions on how his estate will be managed, lawful instructions that can be implemented by law, that for that to happen, it has to have been documented, signed, witnessed, and all of that. And that's what a will is about, or a trust is about. So where the deceased has not done that, then, and all these people cannot be found, then the state will appoint through the administrator general. There's an office. So if you go to the probate registry, or if you go to the office of the administrator general and public trustee, in a ministry of justice of any state, for instance, you would find more guidance. You would find more guidance on this. So the state would come into play, and the administrator general will be the one administering the property on behalf of the deceased. It doesn't mean that these people now own the property. It just means that they are supervising, administering it for the deceased. So anything that is supposed to be done that the deceased would have done, for instance, they will be doing it on behalf of the deceased. They will be making returns and reports, filing reports as to how they are administering it year in, year out, and paying some dues and what have you. So that's the line of succession. So especially for uncles and aunties or brothers and sisters, you see how far they are in the line of succession. So that's all I want to talk about in this video. I will see you in my very next video. Don't forget to subscribe to those.